time again for Let's Talk Legal. Compliments of Neumann van Rooyen Attorneys. And once again this week we have Gerda Janse van Rensburg. Gerda, it's always a pleasure having you.
Thank you, Jason. Thank you as always for the invitation.
Absolutely. So after our previous discussion about cohabitation, we have received a lot of questions about how parties should protect themselves and the rights, etc. of cohabitation. Now, to start the discussion, here is one of the questions that we received. And it goes as follows. My partner and I have been together for 7 years. She is refusing to get married because she does not believe in the institution of marriage. What should I do?
Thanks, Jess. We've also received a couple of questions in the office, and it's a difficult thing because marriage is one of those choices that you make somewhere along the line or not make somewhere along the line, and it's personal preference. But it is important to remember that when you get married in South Africa, there's certain rights and obligations that you get in terms of the Act. And that's different to a couple only living together and doesn't have any rights and obligations towards each other. So in terms of our law, domestic partnerships or people that just stay together are not considered a marriage, and therefore there's no legal rights and consequences. In certain cases, though, a relationship of cohabitation can be equated to a universal partnership. Now, this is the nitty-gritty lawyer stuff that we use from time to time to prove a partnership between two people. But it's difficult to prove in a court of law to say, listen, but we weren't really living together, we were actually in a partnership.
Mm-hmm. Now, that's actually very interesting. How do you prove such a partnership?
So the basics for a partnership is that you can only prove a partnership or a universal partnership if the following requirements exist. And that is that each party is bringing something into the partnership, whether it is money, labor, skills, looking after the children, doesn't matter. A partnership must be for the joint benefit of both parties. It can't be only for one person. The objective should be to make profit. Now, this is usually where staying together becomes a little bit murky because people don't necessarily move in together to make money. And then the partnership goal should be legitimate. It can't be some other dodgy thing that you're doing somewhere. Then it's not deemed to be a partnership.
All right. So what are you to do if you live together, are not planning to get married, and have concerns as to whether your arrangement would qualify as a universal partnership?
Jess, the previous time when we were together, I spoke about cohabitation agreements and when to draft it and when not to. And we had a lot of questions about that, and people don't quite seem to get that you actually can draft a cohabitation agreement and why it's so important. So much of our law attaches certain rights and consequences to the marriages, as we said, but this agreement will help you regulate your relationship consequences if you're only living together. Stuff like who's going to contribute financially to the groceries every month, who's going to pay the flat, who's going to pay the water and lights, what are we going to do the day that we end up leaving each other, who leaves what, when, where, and those kind of things should be in writing. Importantly, such an agreement does not grant you any rights or benefits that is equal to a marriage, but it can provide security. We get a lot of questions from women who says that they've been living with someone for 20, 30, 40 years, raised the children, did everything, but there's not a piece of paper anywhere in sight. But you have to, once again, be open, talk about these things, and if possible, get to the cohabitation agreement so that we know everyone is sorted out and has the security of knowing what's going to happen next.
Absolutely. Now, we also received questions about what will happen if one of the parties should unfortunately pass away.
Jessica, in South Africa, it's all about having a will or not having a will. So it is important to ensure that both of the parties have wills, and in that will that it states who's going to get what if one of the parties passes away. If there isn't a will, unfortunately, the Intestate Succession Act will kick in, and that will mean that your family will probably inherit above the person that you've been living with for 30 years. So yes, there's a court case now that said yes, there's a right for maintenance, but it's probably going to end up in the Constitutional Court. It's very murky. It isn't clear on what's going to happen when or where. So it's important to sort these stuff out, see to it that you have a will, and that everyone understands what's going to come, and especially if there's children involved, to make sure that the children knows what's going to happen if mom or dad passes away.
Absolutely. So there you have it. Some of the most important steps you can take to ensure that your partnership arrangements are clear and the rights and consequences of both parties are spelled out during the relationship and following its termination through a breakup or death. Gerda, once again, thank you so much for coming to the studio to chat about some of the things that we don't necessarily always think about, but I think you really did cover the situation very well for us today.
Thank you, Jess. Thanks for the invite.
So there you have it. That was, of course, Gerda Janse van Rensburg from Neumann van Rooyen Attorneys. If you would like some more information, remember you can go and visit www.nvrlaw.co.za.